There now have been responses to the bombshell motion that Team Trump dropped on Friday with the cell phone records of prosecutor Nathan Wade. I mean, an extraordinary thing. One of the questions I asked you was, how do they get their hands on the prosecutor's cell phone records? And you said they issued a subpoena and you're allowed to do that. And sure enough, we now have Fani Willis's response to the Trump motion saying a bunch of stuff. She says, it's too late. We already kind of closed the hearing. You're too late. And by the way, you can't submit opinion testimony or expert testimony like this without meeting a couple of foundational things, like qualifying the guy as an expert, and you didn't do any of that. And they also say this doesn't really prove what you think it proves. And they say kind of what I was saying, which was, you may have gotten these illegally. You didn't, how'd you get these? They seemed surprised that the defense had managed to get this too. And now we also have Trump's reply trying to address each of those points. So I know you've read the briefs. What do you make of where we are on these arguments?
Yeah. Well, I think that the response that the state filed, I guess, late on Friday was a lot of it was ridiculous. We setting aside they tried to present Willis as having some kind of an alibi for the sleepover dates that were claimed in September and November, and they attached screenshots or PDFs of her calendar for dates in like April and May that had nothing to do with the dates in question. So putting that issue to the side, one of the most ridiculous claims that they made was that the defense had no legal way of getting this. Well, I said it, and I think you said it, others have said it. Compulsory process means that lawyers get to subpoena witnesses and evidence in their favor. And this is one of the biggest tools defense lawyers have to defend their clients and to get information. The cops in the investigative stage, they need a warrant. It's got to be supported by probable cause. That's Fourth Amendment. But we are now dealing with the Sixth Amendment. Now that you've brought criminal charges, the defense gets to investigate the case and they get to present evidence that's favorable to them. Trump, in his footnote on page 2, his lawyer says, the records were obtained by a valid subpoena issued to AT&T, and they say that the state's claim in that response that it was somehow illegal is patently frivolous. Okay, they said that and I agree, it was kind of a frivolous argument to make, and it's not the kind of thing I would be expecting from professional prosecutors. But the Trump motion, the recent response points out that this is not opinion testimony. This is direct evidence. It's what we call impeachment evidence. And in the legal sense, what that means is that you're basically attacking the credibility or the substance of what somebody has said in court. In this case, Wade and Willis have said that, these overnight visits didn't happen. Well, this is meant to contradict their testimony. And this is something that is also allowed by the rules of evidence. It's not that Charles Middlestat, the investigator, is coming to offer his opinion on things. He's coming to present the data. What is it that was collected? And he can offer a summary of it. So Trump is, I think, right on that point. He's right that the information was obtained legally. He's right on the point that it means that there's strong circumstantial evidence that these meetings, overnight meetings, we talked about on Friday, the kitchen cabinet or whatever that means, these things did occur. And this is not conclusive evidence that they were necessarily having sex or anything like that. But what it is, it's circumstantial evidence that corroborates Yurdi, and it contradicts their direct testimony in court. So it goes to prove two things. It goes to prove that they possibly might be lying to the judge in this case, and it goes to show that the conflict of interest is real and that it began much earlier than Willis and Wade have said that it did. So honestly, if I had to be keeping score right now, I would say the Trump team is clearly winning, at least in the battle of the competing briefs here. But the arguments that were raised by the state in objection to these records, I thought was really not that great. And honestly, I agree with the characterization that some of the claims are frivolous and just outright ridiculous.
It was thin, to put it mildly. There were the two overnights, September 11th, 2021, which last I checked is earlier than 2022, and then November 29th, 2021. Those are the two nights submitted by Team Trump showing that his cell phone appeared to have left his address and arrived near or at her address. The first one was from 10:45 p.m., leaving at 3:28 a.m., and then at 4:20 a.m., he texted Fani Willis. I mean, my God, as you said, it's the got home safely text, seems clear. And then November 29 of 21, he again left his area, his residence at 11:32 p.m. and then returned back home after visiting her area at 4:55 a.m. On neither of those two nights is any contradictory record, testimony, location information provided by Fani Willis in her opposition. She submits some emails, all of which are redacted, heavily redacted, to show the cell phone records Team Trump submitted are wrong. They're not reliable. Since they're almost entirely redacted, I can't really tell for sure, but what they seem to be, to me, Phil, tell me what you think, is a bunch of emails of Fani Willis potentially saying, here, I'm at work, come meet me, or meet me at the office at X time, and it appears to be a time at which Nathan Wade is shown at her home residence. I'm taking a guess. I don't understand how her emails on various dates having nothing to do with the two overnights can disprove Trump's case, other than to perhaps, if they prove positively that she was at the office when she sent them. And I do not believe they've submitted any such evidence. They've submitted emails from her work account. I can send that right now from Devil May Care Media. It doesn't mean I'm at corporate headquarters, right? Like I'm not sure what she's trying to prove, but they don't address the two overnights at all.
They don't. They simply attach those emails, and the dates on the emails, at least the ones that I saw and that I remember seeing, were not on the dates in question. One of them was in November, but it was a different day. Then the calendars we talked about were from April and May. I think there was something from August, but there was nothing that responded directly to the claim that the cell data was strong circumstantial proof that he was at the Yurty condo in Hapeville, Georgia overnight on those two nights in September and November. Nathan Wade talked about in the hearing, well, you got the Porsche experience down there, which is actually a great place, but it is down in Hapeville near near the Atlanta airport. But nobody ever claimed that he was actually at the Porsche experience, at midnight or 1 o'clock in the morning. There was some suggestion in the state's filing that this is a generalized data location, which happens to put him also near bars and restaurants. There was no allegation. Nobody ever said he was actually at any bar or restaurant, or that any bar or restaurant was even open.
I was going to say, Phil, you're a local. Are the bars open at 5 a.m., 4 a.m., and 5 a.m. in
Well, I can't.
This area?
I'm too old to know. That was maybe an earlier time in my life I would know.
Even in the Yankee states, the bars close at 2. Most bars close at 2. Down in the South, there's no way they're open at 5 a.m.
So here's the big thing about these text messages, though. Do you know, if you noticed that when the cell phone stopped moving, right, and it was down there near the Yurty condo and apparently also near bars and restaurants and all this, the texting and the calling between Wade and Willis stopped. Okay, and I think that's a big point. That, if he's texting and calling other people at 3, 4, 5 o'clock in the morning, that might weigh in favor of the Willis and Wade team. But the calling and the texting apparently stopped until he left and resumed his travels back to his home in Cobb County, according to the motions that we've seen.
They had something else to do. Okay, here's a little color from the state's response to Team Trump. They say these records do not prove in any way the content of the communications between Wade and Willis. They don't prove that Wade was ever at any particular location or address. I think Team Trump would concede that. It's circumstantial that they believe he was at her house. They do not prove that Wade and Willis were ever in the same place during any of the times listed. And in fact, multiple relevant dates and times, on multiple relevant dates and times, evidence clearly demonstrates that Willis was elsewhere, including at work. That's the blacked out emails. Okay. Now, Team Trump responds by saying, all right, the prosecution will surely point out nobody knows what was happening in the house between midnight and 3:28 a.m. on September 12th or between midnight and 5 a.m. on November 30th. Middlestat, that's their phone analyst, the guy who's doing the cell phone tower data, does not claim to know. Neither does President Trump or any other defendant in this case. Only two people know. They are certainly the ones who should testify and say exactly what was happening on those occasions, so nobody will complain about improper speculation or improper efforts to distort the truth or nefarious contacts with the media. All we have heard from Wade and DA Willis so far has been that they did not have a romantic relationship until 2022. Yet it is highly significant that the state's response did not even attempt to challenge this phone evidence regarding those two dates. So they're raising the same thing we're raising, Phil, which is in all those attached emails and even the response, and they didn't submit a new affidavit, there's been zero attempt to explain why his cell phone would be what appears to be at her house or right near it for 2 overnights, contrary to what they represented to the court. I want to tell you about the Association of Mature American Citizens, or AMAC, an organization dedicated to America's seniors. AMAC stands out today by not only advocating for senior issues, but also by pushing for conservative values that affect us all. Did you know you were in a left-wing organization if you're over there in that other one? If you join this organization, you're not just supporting America's senior citizens, you can become part of a movement defending our freedoms and securing our nation's future. Plus, membership brings you exclusive benefits like discounts on travel, dining, entertainment, special insurance rates even. Regardless of your age, if you are driven to preserve freedom, AMAC welcomes you. Sign up now at amac.us/Megyn. And for a limited time, get a free gift membership for someone who shares your love of our great nation. Don't miss out on this chance to make a difference with AMAC. Join today at amac.us/Megyn and extend the invitation to a friend or a family member for free. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.